Crimes against national security and the law of nations. 114 to 123. Q. What are the crimes against national security under the RPC? The crimes are treason, 114. Conspiracy and proposal to commit treason, 115. Misprision of treason, 116. And 117, espionage. What are the crimes against the law of nations under the RPC? 1. Inciting to war or giving motives for reprisals. 2. Violation of neutrality. 3. Correspondence with hostile country. 4. Flight to enemy's country. 5. Piracy in general and mutiny in the high seas or in Philippine waters. And 6. Qualified piracy. Treason. What is the crime of treason? Treason is a breach of allegiance to a government committed by a person who owes allegiance to it. It is a violation by a subject of his allegiance to his sovereign or to the supreme authority of the state. Q. Define allegiance. What are the types of allegiances? Allegiance is the obligation of fidelity and obedience which the individuals owe to the government under which they live or to their sovereign in return for the protection they receive. Allegiance may be permanent or temporary. Permanent allegiance is owed by a person to his country. Temporary allegiance, on the other hand, is the obligation of fidelity and obedience which resident aliens owe to the government of the country in which they are sojourning. Laurel versus Misa. What are the elements of treason? Under Article 114 of the RPC, the elements of treason are 1. That the offender is a Filipino citizen or an alien residing in the Philippines. 2. That there is a war in which the Philippines is involved. And 3. That the offender either mode of committing levies war against the government or B. adheres to the enemies and give them either aid or comfort. Q. Distinguish between treason committed by a Filipino citizen and by that a resident alien. A Filipino citizen may commit treason anywhere while an alien can only be punished with this crime if the same was committed in the Philippines, except in cases of conspiracy. This is because the Filipino citizen owes permanent allegiance, which follows his person. The alien must be residing in the Philippines because as only a resident or sojourning alien has the obligation to temporary allegiance to the Philippine government. Can treason be committed during peacetime? No. Treason cannot be committed in times of peace, although treasonable acts may be perpetrated during peacetime. Until the outbreak of war, such acts do not yet constitute the crime of treason. This is because the law on treason is an emergency statute that only into operation during wartime. It is for this reason that the law on treason cannot be suspended during wartime. In fact, it can only be on operation in wartime. No, without any intention of helping an external enemy, the crime is not treason. Instead, the offender may be held liable for rebellion under Article 135 in relation to Article 134. Q. Is it necessary that there be a formal declaration of the existence of a state of war? No. Actual hostilities may determine the date of the commencement of war. Q. What does it mean to levy war? Levying war requires the concurrence of two things. 1. That there be actual assembly of men. And 2. That the assembly be for the purpose of executing a treasonable design by force. Note, absence of intent to overthrow the government will not amount to treason, but is punishable under rebellion. Q. What does adherence to the enemy and aid of comfort mean with regard to the commission of treason? Adherence to the enemy pertains to the demonstrated intent to betray, which is committed when a person who owes allegiance to the state intellectually or emotionally favors the state's enemy and harbors sympathies or convictions disloyal to his country's policy or interest. Aid or comfort. on the other hand, refers to acts which strengthens or tends to strengthen the enemy in the conduct of war against the traitor's country, or an act which weakens or tends to weaken the power of the traitor's country to resist, or to act which weakens or tends to weaken the power of the traitor's country to resist or to attack the enemy. The aid or comfort must be given to the enemy by some kind of action. It must be a deed or physical activity, not merely a mental operation. Kramer versus U.S. Note, adherence alone, without giving the enemy aid or comfort, does not constitute treason. Both adherence and the giving of aid or comfort to the enemy must concur. Q. Can there be a treason through negligence? No. The overt act of aid and comfort to the enemy must be intentional or distinguished from merely negligent or undersigned. How is treason proved? The following are the ways of proving treason. Testimony of at least 2 witnesses to the same overt act, 2-witness rule. Or 2. Confession of guilt by the accused in open court. Article 114. What is the 2-witness rule? Under this rule, the testimony of 2 witnesses is required to prove the overt act of levying war or giving aid or comfort. The rule ensures that the court is given the opportunity to detect falsehood when observing any variance in the details of 2 testimonies to the same act. People versus Adriano. Q. Under the 2-witness rule, is the witness still required to prove the accused's adherence to the enemy? Proof of adherence is exempted from the 2-witness rule because adherence is not an overt act but a state of mind. It is sufficient that the testimony of at least one of the 2 witnesses to the same overt act of levying war or giving aid or comfort is also able to demonstrate the accused's adherence to the enemy. It may also be shown from the nature of the act itself or from the circumstances surrounding the act. Kramer versus U.S. Q. It is necessary that the testimonies of the 2 witnesses be identical? No. Their testimonies need not be identical. What is necessary is that the testimonies of the 2 witnesses coincide for the same act of giving aid or comfort. People versus Concepcion. How is conspiracy to commit treason committed? Conspiracy to commit treason is committed when in time of war, 2 or more persons come to an agreement to levy war against the government or to adhere to the enemies and give them aid or comfort and decide to commit. Articles 8 and 114. How is proposal to commit treason committed? Proposal to commit treason is committed when in time of war, a person who has decided to levy war against the government or to adhere to the enemies and to give them aid or comfort proposes its execution to some other person or persons. Articles 8 and 114. Is the 2-witness rule necessary to prove conspiracy and proposal to commit treason? No. These crimes are separate and distinct offenses from that of treason because Article 115 of the RPC does not provide for the same rule of evidence as Article 114. The 2-witness rule need not be applied. U.S. versus Bautista. Misprision of treason. What is misprision of treason? It is the failure of a citizen to report as soon as possible a conspiracy against the government which comes to his knowledge, but there must be a war in which the Philippines is a party. Boado notes cases on RPC. Q. What are the elements of misprision of treason? Under Article 116 of the RPC, the elements of misprision of treason are CKC, that the offender is a citizen of the Philippines. Note, a resident foreigner cannot commit this felony. 2. That he has knowledge of any conspiracy to commit treason against the government. And 3. That he conceals, does not disclose, or does not make the same known as soon as possible to the proper authority. Note, Article 116 is an exception to the rule that mere silence does not make a person criminally liable. Q. Can misprision of treason still be prosecuted when the treason has been committed? No. Misprision punishes the omission of the duty to report to the state the existence of a budding conspiracy. Once the treason is committed, the reason behind the law disappears. Espionage. What is espionage? Espionage is the offense of gathering, transmitting, or disclosing information respecting the national defense with intent or reason to believe that the information is to be used to the injury of the Republic of the Philippines or to the advantage of a foreign nation. What are the two ways of committing espionage? Under Article 117 of the RPC, there are two ways of committing espionage, e.d. by entering without authority a warship, fort, or military or naval establishment or reservation to obtain any information, plans, or other data of confidential nature relative to the defense of the Philippines, or 2. by disclosing to the representative of a foreign nation the contents of the articles, data, or information referred to in the preceding number, which he had in his possession by reason of the public office he holds. What are the elements of the first mode of committing espionage? The elements are PNP, that the offender enters into the place mentioned in Article 117, that he has no authority therefore, and 3. that his purpose is to obtain information, plans, or other data of a confidential nature relative to the defense of the Philippines. Note, it is not necessary that the information is actually obtained. It is sufficient that the offender had the intention to obtain such information. What are the elements of the second mode of committing espionage? The elements are OPD, that the offender is a public officer, that he has in possession the articles, data, or information referred to in Article 117, Paragraph 1, by reason of the public office he holds, and 3. that he discloses their contents to a representative of a foreign nation. Book 2. Distinguish espionage from treason. Espionage and treason may be distinguished as follows. Treason, as to when committed. Treason is committed only in time of war. Espionage may be committed both in time of peace and in time of war. As to manner of commission, treason is limited in two ways in committing the crime, which may either be levying war or adhering to the enemy, giving him aid and comfort. Espionage may be committed in many ways. Section 2. Provoking war and disloyalty in case of war, inciting to war or giving motive for reprisal. The elements are UPE. 1. That the offender performs unlawful or unauthorized acts, and 2. that the unauthorized acts will provoke or give occasion for a war involving or liable to involve the Philippines. E. Expose Filipino citizens to reprisals on their persons or property. Note, the crime is committed regardless of the intention of the accused. This crime is committed in time of peace. Penalty is higher when the offender is a public officer or employee. Violation of neutrality. What are the elements of violation of neutrality? Under Article 119 of the RPC, the elements are WIO, that there is a war in which the Philippines is not involved. 2. That there is a regulation issued by a competent authority for the purpose of enforcing neutrality, and 3. that the offender violates such regulation. Correspondence with hostile country. Q. What are the elements of correspondence with hostile country? Under Article 120 of the RPC, the elements are TM, PCC. This is made in time of war in which the Philippines is involved. That the offender makes correspondence with the A. enemy country, or B. territory occupied by the enemy troops, and 3. that the correspondence is A. prohibited expressly by the government, B. carried on in ciphers or conventional signs, C. contains notice or information which might be useful to the enemy, whether or not it is intended to aid the enemy. What is the meaning of correspondence? Correspondence is communication by means of letters, or it may be referred to the letters which pass between those who have friendly or business relations. Note, if the offender intended to aid the enemy by giving such notice or information, the crime amounts to treason. If the act prosecuted Under Article 120, the act is punished with the same penalty as treason. Flight to enemy's country. Q. What are the elements of flight to enemy's country? The elements are WAAG. 1. That there is a war in which the Philippines is involved. 2. That the offender owes allegiance to the government. 3. That the offender attempts to flee or go to the enemy country. And 4. That going to the enemy country is prohibited by the competent authority. Can a resident alien be guilty of the crime of flight to enemy's country? Yes. A resident alien owes allegiance to the Philippine government temporarily. Section 3. Piracy and mutiny on high seas or in Philippine waters. Piracy in general and mutiny on the high seas or in Philippine waters. What is piracy? Piracy is robbery or forcible predation on the high seas without lawful authority and done with animo furandi or intention to steal, and in the spirit and intention of universal hostility. People versus law. What is the meaning of high seas? There are parts of the seas that are not included in the territorial seas or in the internal waters of a state or in the archipelagic waters of an archipelagic state. UN Clause Article 86. What are the two modes of committing piracy under the RPC? The two modes of committing piracy are as 1. By attacking or seizing a vessel on the high seas or in Philippine waters, or 2. By seizing in the vessel while on the high seas or in Philippine waters the whole or part of its cargo, its equipment, or the personal belongings of its complement or passengers. What are the elements of piracy? The elements are VCAS. That a vessel is on the high seas or in the Philippine waters. 2. That the offenders are not members of its complement or passengers of the vessel. And 3. That the offenders attack or seize the vessel, or B. Seize the whole or part of the cargo of said vessel, its equipment, or the personal belongings to its complement or passengers. Q. What if the acts enumerated under Article 122 were committed by members of its complement or its passengers? When the same acts are committed by the ship's complement or by its passengers, offenders may be liable for robbery, mutiny, or other crimes as may be appropriate to the facts and circumstances of the case. What is mutiny? Mutiny is unlawful resistance to a superior officer, or the raising of commotions and disturbances on board a ship against the authority of its commander. Bouvier's Law Dictionary. Distinguish mutiny from piracy. Piracy under the RPC may be distinguished with mutiny in the following manner. Piracy as to place of commission, enter in the Philippine waters or in the high seas, the same with mutiny. As to person committing piracy, persons who attack a vessel or seize its cargo are strangers to the vessel, committed by persons who, while being strangers to the vessel, attack said vessel or seize its cargo. Mutiny, committed by members of the crew or its passengers. As to criminal intent, piracy, intent to gain, is essential. Mutiny, the offenders may only intend to ignore the ship's officers, or they may be prompted by the desire to commit plunder. Qualified piracy. How is qualified piracy committed? Piracy is qualified whenever 1. The offenders have seized the vessel by boarding or firing upon the same. 2. The pirates have abandoned their victims without means of saving themselves. 3. The crime is accompanied by murder, homicide, physical injuries, or rape. Q. What are the punishable acts under PD 532? The punishable acts are piracy, PD 532, Section 3, letter A. Number 2, highway robbery, brigandage, PD 532, Section 3, letter B. And 3, aiding pirates or highway robbers, brigands, or abetting piracy or highway robbery or brigandage. PD 532, Section 4. What is the definition of Philippine waters under PD 532? Philippine waters refer to all bodies of water, such as but not limited to seas, gulf, bays around, between, and connecting each of the islands of the Philippine archipelago, irrespective of its depth, breadth, length, or dimension, and all other waters belonging to the Philippines by historic or legal title, including territorial sea, the seabed, the insular shelves, and other submarine areas over which the Philippines has sovereignty or jurisdiction. What is a vessel? A vessel is any vessel or watercraft used for transfer of passengers and cargo from one place to another through Philippine waters and includes all kinds and types of vessels or boats used in fishing. PD 532, Section 2, letter B. What is piracy under PD 532? Piracy is defined as any attack upon or seizure of any vessel, or the taking away of the whole or part thereof, or its cargo, equipment, or the personal belongings of its complement or passengers, irrespective of the value thereof, by means of violence against or intimidation of persons or force upon things committed by any person, including a passenger or member of the complement or said vessel. In Philippine waters, PD 532, Section 2, letter D. How is piracy under PD 532 different from Article 122 of the RPC as amended by RA 7659? Piracy is concurrently punishable under PD 532 and the RPC when it is committed in Philippine waters. If it is committed on the high seas, it is punishable only under the RPC. Moreover, under PD 532, piracy can be committed by any person and can therefore also cover acts of piracy committed by the vessel's complement and passengers. However, when piracy is committed by persons other than members of the complement or passengers, it is only punishable under the RPC. Article 122 as amended versus PD 532. As to persons covered under Article 122, A. In case of an attack on or seizure of vessel, any person. B. In case of seizure of whole or part of the cargo, equipment, or personal belongings, excludes crew, members, or passengers. Under PD 532, any person, including a passenger or member of the complement of said vessel. As to situs of piracy, Article 122, Philippine waters and the high seas. Under PD 532, Philippine waters only. What is highway robbery or brigandage? Highway robbery or brigandage is the seizure of any person for ransom, extortion, or other unlawful purposes, or the taking away of the property of another by means of violence against or intimidation of persons, or force upon things, or other unlawful means committed by a person, any person on any Philippine highway. PD 532, Section 1. What are punishable acts under PD 6235? They are the following. PFS. To compel a change in the course of destination of an aircraft of Philippine registry, or to seize or usurp the control thereof while in its flight. PD 6235. Number 2. To compel an aircraft of foreign registry to land in the Philippine territory, or to seize or usurp the control thereof while it is within the said territory. PD 6235, Section 1. And 3. To ship, load, or carry in any passenger aircraft operating as a public utility within the Philippines any explosive, flammable, corrosive, or poisonous substance or material. PD 6235, Section 3. Human Security Act of 2007, RA 9372. Q. What is terrorism? Any person who commits any act of the following acts, thereby sowing and creating a condition of widespread and extraordinary fear and panic among the populace in order to coerce the government to give in to an unlawful demand, shall be guilty of the crime of terrorism. 1. Piracy in general and mutiny in the high seas or in the Philippine waters. Article 122. Number 2. Rebellion or insurrection. Article 134. 3. Coup d'etat, including acts committed by private person. Article 134-A. 4. Murder, Article 248. 5. Kidnapping and serious illegal detention, Article 267. 6. Crimes involving destruction, Article 324. A. Arson, PD 1613. B. Crimes under the Toxic Substances and Hazardous and Nuclear Waste Control Act of 1990, RA 6969. C. Crimes under the Atomic Energy Regulatory and Liability Act of 1968, RA 5207. 7. Crimes under the Anti-Hijacking Law, RA 6235. 8. Crimes under the Anti-Piracy and Anti-Highway Robbery Law of 1974, PD 532. Crimes under the Decree codifying the laws on illegal and unlawful possession, manufacture, dealing in, acquisition, or disposition of firearms, ammunition, or explosives, PD 1866 as amended. Note, conspiracy to commit terrorism is also punishable, RA 9372, Section 3 and 4. Crimes against the fundamental laws of the state, Articles 124 to 133 of the RPC. Under the revised penal code, what are the crimes against the fundamental laws of the state under the RPC? The crimes are the following. 1. Arbitrary detention, 124. 2. Delay in the delivery of detained person to the proper judicial authorities, 125. 3. Delaying release, 126. Expulsion, 127. Violation of domicile, 128. Search warrants maliciously obtained and abused in the service of those legally obtained, 129. Searching domicile without witnesses, 130. Prohibition, interruption, and dissolution of peaceful meetings, 131. Interruption of religious worship, 132. And number 10, offending the religious feelings, 133. Section 1. Arbitrary detention and expulsion. What are the elements of arbitrary detention? The elements are PDD. That the offender is a public officer or employee. That he detains a person, and 3. The detention is without legal ground. What is detention? Detention is defined as the actual confinement of a person in an enclosure or in any manner detaining and depriving him of his liberty. People v. Flores. Detention need not involve physical restraint. Psychological restraint which results from fear is deemed sufficient, as Torga v. People. What are the legal grounds for the detention of a person? 1. The commission of a crime. 2. Violent insanity or other ailment requiring the compulsory confinement of the patient in the hospital. Article 124, Paragraph 2. Delay in the delivery of detained persons to the proper judicial authorities. What are the elements of delay in the delivery of detained persons to the proper judicial authorities? The elements are PDF. 1. That the offender is a public officer or employee. That he has detained a person for some legal ground. Rules of Court 113, Section 5. 3. That he fails to deliver such person to the proper judicial authorities within A. 12 hours for offenses punishable by light penalties or their equivalent. B. 18 hours for offenses punishable by correctional penalties or their equivalent. C. 36 hours for offenses punishable by afflictive penalties or their equivalent. Q. What is the meaning of delivering the person to the proper judicial authorities? The phrase does not consist in a physical delivery by making an accusation or charge or filing of an information against the person arrested with the corresponding court or judge, whereby the latter acquires jurisdiction to issue an order of release or of commitment of the prisoner. Lava v. Gonzalez. May a police officer acting by virtue of a valid warrant of arrest who detains a person and fails to deliver such person to proper judicial authorities within the time prescribed be held criminally liable. Article 125 applies only when the arrest is made lawfully without warrant of arrest. Since there is already a complaint or information filed against him with the court which issued the order or the warrant of arrest, it shall no longer be necessary to deliver the person thus arrested to that court. The answer is no. Delaying release. What are the elements of delaying release? PJSPP. That the offender is a public officer or employee. 2. That there is judicial or executive order for the release of a prisoner or detention prisoner, or that there is a proceeding upon a petition for the liberation of such person. And 3. That the offender without good reason delays the service of the notice of such order to the prisoner, or the performance of such judicial or executive order for the release of the prisoner, or C. The proceedings upon a petition for the release of such person. Expulsion. What are the elements of expulsion? PEN. 1. That the offender is a public officer or employee. That he expels any person from the Philippines or compels a person to change his residence. And 3. That the offender is not authorized to do so by law. Note, only a court by final judgment can order a person to change his domicile. What are the acts punishable under this provision? The punishable acts are 1. By expelling a person from the Philippines, and 2. By compelling a person to change his residence. What are the elements of violation of domicile? The elements are POW, ESR. The offender is a public officer or employee. 2. The offender is not authorized by judicial order to enter the dwelling and or to make a search for papers or other effects. And 3. The offender shall A. Enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, and C. Refuse to leave the premises after having surreptitiously entered such dwelling and after having been required to leave the same. What is the meaning of against the will of the owner in connection to the crime of violation of domicile? The phrase presupposes opposition or prohibition by said owner, whether expressed or implied. If the entrance by the public officer or employee is only without the consent of the owner of the dwelling, the crime is not yet committed until he is asked to leave and he refuses. U.S. v. Chua. What are the qualifying circumstances in violation of domicile? 1. When the offense was committed at night time, and if any papers or effects not constituting evidence of a crime are not returned immediately after the search made by the offender. Search warrants may maliciously obtained and abused in the service of those legally obtained. What are the acts punishable under Article 129 of the RPC? 1. Procuring a search warrant without just cause. And 2. Exceeding his authority by using unnecessary severity in the execution of a search warrant legally procured. What are the elements of procuring a search warrant without just cause? 1. That the offender is a public officer or employee, that he procures the search warrant and that there is no just cause, PPJ. How can you determine the absence of a just cause in the issuance of a search warrant? A search warrant is said to have been procured without just cause when it appears on the face of the affidavit filed in support of the application therefor, or through other evidence that the applicant had every reason to believe that the search warrant sought for was unjustified. What are the elements of abuse in the service of legally obtained search warrants? The elements are PLE, that the offender is a public officer or employee, that he has legally procured a search warrant, and that he has exceeds his authority to or uses unnecessary severity in executing the same. What are the elements of searching domicile without witnesses? The elements are PASO, that the offender is a public officer or employee, that he searches the domicile, papers, or other belongings of any person, that he is armed with search warrant legally procured, and that the owner or any member of his family or two witnesses residing in the same locally are not present. What kinds of searches are contemplated by Article 130? Article 130 is limited to the improper execution of a search warrant to a home used as a domicile and the papers and other belongings of a person. It therefore excludes warrantless searches, whether performed lawfully or not, as they do not involve the execution of a search warrant. It also excludes the search of vehicles, even if the vehicle is a boat, house, a mobile home, or is used as such by the owner, because a vehicle cannot be treated as a domicile under the law. Section 3. Prohibition, interruption, and dissolution of peaceful meetings. What are the punishable acts in connection with peaceful meetings, associations, and petitions? The punishable acts are MAP, M-A-P, prohibiting, interrupting, or dissolving without legal ground the holding of a peaceful meeting, hindering any person from joining any lawful association or from attending any of its meetings, and 3. Prohibiting or hindering any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuse or redress of grievances. What are the elements common to the acts mentioned in the immediately preceding answer? Papa. That the offender is a public officer or employee, and that he performs any of the acts enumerated in violation of the right to association and peaceful assembly, PAPA. Is the right to peacefully assemble absolute? No. Although the right is guaranteed by the Constitution, it is not absolute, for it may be so regulated that it shall be not injurious to the equal enjoyment of others having equal rights, nor injurious to the rights of the community or society through the state's exercise of police power. Can the crime be committed by a member or participant of the peaceful assembly who happens to be a public officer? The offender must be a stranger to the peaceful assembly and not a participant thereof, or even if he began as a bona fide participant, he disrupts the same in his official capacity for the purpose of breaking up the assembly. Therefore, a person who happens to be a public officer will not be liable for this offense when his actions are merely private in character. Section 4. Crimes against religious worship. What are the crimes against religious worship? 1. Interruption of religious worship, Article 132, and 2. Offending religious feelings, Article 133. What are the elements of interruption of religious worship? The elements are PREP. That the offender is a public officer or employee, that religious ceremonies or manifestations of any religion are about to take place or going on, and that the offender prevents or disturbs the same. Note, a higher penalty shall be imposed if the crime is committed with violence or threats. Offending religious feelings. What are the elements of offending religious feelings? PDA. No. That the act complained of were performed in A. a place devoted for religious worship, or B. during the celebration of a religious ceremony, and that the acts must be notoriously offensive to the feelings of the faithful. What are religious ceremonies? Religious ceremonies are those religious acts performed outside of a church, such as processions and special prayers for burying dead person. Crimes against public order, RPC Articles 134 to 160. What are the crimes against public order under the RPC? The following are the crimes against public order. 1. Rebellion or insurrection, 134. Coup d'etat, 134A. Conspiracy and proposal to commit coup d'etat, rebellion or insurrection, 136. Disloyalty of public officers or employees, 137. Inciting to rebellion, 138. Sedition, 139. Conspiracy to commit sedition, 141. Inciting to sedition, 142. Acts tending to prevent the meeting of Congress and other similar bodies, 143. Disturbance of proceedings of Congress or similar bodies, 144. Violation of parliamentary immunity, 145. Illegal assemblies, 146. Illegal associations, 147. Direct assault, 148. Indirect assault, 149. Disobedience to summons issued by Congress, its committees, etc., by the constitutional commissions, its committees. 150. Resistance and disobedience to a person in authority or the agents of such person. 151. Tumults and other disturbances of public order. 153. Unlawful use of means of publication and lawful utterance. 154. Alarms and scandals. 155. Delivering prisoner from jails. 156. Evasion of service of sentence. 157. Evasion on occasion of disorders. 158. Violation of conditional pardon. 159. And commission of another crime during sentence of penalty imposed for another previous offense. Article 160. Chapter 1. Rebellion, coup d'etat, sedition, and disloyalty. What are political crimes? Political crimes are those directly aimed against the political order, as well as such common crimes as may be committed to achieve a political purpose. The decisive factor to determine if a crime is political is the intent or motive. Thus, if a crime is usually regarded as common, like homicide, is perpetrated for the purpose of removing the allegiance to the government, the territory of the Philippine Islands, or any part thereof, then said offense becomes stripped of its common complexion. Inasmuch as being part and parcel of the crime of rebellion, the former acquired the political character of the latter. Ocampo versus Abando. What are the elements of rebellion or insurrection? Part 1. That there is uprising, public uprising, and taking up of arms against the government. Number 2. That the purpose of such act is to remove the allegiance of said government or its laws, the territory of the Philippines or any part thereof, or any body of land, naval, or other armed forces, or deprive the chief executive or Congress, wholly or partially, of any of their powers or prerogatives. Note, acts which aim to deprive the judiciary of its powers or prerogatives is punished as sedition under Article 139. Q. Is the actual clash of arms necessary in rebellion? Actual clash of arms is not necessary to make one liable for rebellion. Identifying oneself with an organization openly fighting to overthrow the government is enough. Amurao, Commentaries on Criminal Law. Distinguish rebellion from insurrection. The term rebellion is more frequently used where the object of the movement is completely to overthrow and supersede the existing government, while insurrection is more commonly employed in reference to a movement which seeks merely to effect some change of minor importance, or to prevent the exercise of governmental authority with respect to particular matters or subjects. Distinguish rebellion from treason. Rebellion and treason may be distinguished in the following manner. Rebellion as to manner of commission. It is committed by rising publicly and taking arms against the government and for any purpose specified in Article 134. While treason, it is committed merely by levying war against the Philippine government, or merely by adherence to the enemy, giving such enemy aid and comfort. As to the time of commission, rebellion in times of peace, treason in times of war. As to the person committing rebellion, any person; treason, only Filipino citizens or an alien residing in the Philippines. As to the place of commission, only in the Philippines for rebellion; treason in the Philippines or elsewhere. As to purpose, rebellion, it has for the purpose the removal from the allegiance to said government of its laws, the territory of the Republic of the Philippines or any part thereof, or any body of land, naval, or other armed forces, or deprivation of the chief executive or the legislature, wholly or partially, of any of their powers or prerogatives. Under treason, delivery of the Philippines to a foreign power. As to evidence required for conviction, two-witness rule does not apply in rebellion. There must be a testimony at least 2 witnesses to the same overt act in treason. As to classification, rebellion, crime against public order; treason, crime against national security. Who may be liable for the crimes of rebellion or insurrection? The persons liable for rebellion or insurrection are any person who promotes, maintains, or heads a rebellion or insurrection, and 2. The person merely participating or executing the commands of others in a rebellion or insurrection. Can there be a complex crime of rebellion with murder and other common crimes? No. Any or all of the acts described in Article 135, when committed as means to or in furtherance of the subversive ends described in Article 134, become absorbed in the crime of rebellion and cannot be regarded or penalized as distinct crimes in themselves. People versus Geronimo. Note, however, in the same cited case, the Supreme Court held that if the killing, robbing, etc. during the rebellion were done for private purposes or profit without any political motivation, the crimes would be separately punished. What are the elements of coup d'etat? The elements are that the offender is a person or persons belonging to a military or police or holding any public office or employment. Number 2, that it is committed by means of a swift attack accompanied by violence, intimidation, threat, tragedy, or stealth. 3, that the attack is directly against duly constituted authorities of the Republic of the Philippines or any military camp or installation or communication networks, public utilities, or other facilities needed for the exercise and continued possession of power. And 4, that the purpose of the attack is to seize or dismiss state power. Note, coup d'etat is an act of terrorism under RA 9372 when it is committed in a manner which tends or intends to create a condition of widespread fear or panic in order to pursue its objectives. Distinguish rebellion from coup d'etat. Rebellion and coup d'etat may be distinguished as follows. Rebellion as to the manner of commission. It is committed by rising publicly and taking arms against the government for any purpose specified in Article 134. Coup d'etat as to the manner of commission. It is a swift attack accomplished by violence, intimidation, threat, tragedy, or stealth. As to the object against which the attack is committed, rebellion directed against the government as a whole or the chief executive or the Congress. Coup d'etat directed against the duly constituted authorities of the Republic of the Philippines or any military camp or installation, communication networks, public utilities, or other facilities needed for the exercises and continued possession of power. As to the person committing rebellion, any person, coup d'etat, only those belonging to the military or police or holding any public office or employment. As to the purpose, rebellion, it has for the purpose the removal from the allegiance to said government or its laws, the territory of the Republic of the Philippines or any part thereof, or any body of land, naval, or other armed forces, or deprivation of the chief executive of the legislature, wholly or partially, of any of their powers or prerogatives. Coup d'etat. The purpose of coup d'etat is to seize or diminish state power. Who may be liable for the crime of coup d'etat? The following are liable for coup d'etat: the person who leads or in any manner directs or commands others to undertake a coup d'etat, and any person in the government service who participates or in any manner supports, finances, abets, or aids in undertaking a coup d'etat. Note, any person not in the government service who participates or in any manner supports, finances, abets, or aids in undertaking a coup d'etat is also liable for a coup d'etat. In case the leaders of the rebellion, insurrection, and/or coup d'etat are unknown, who will be deemed as the leader for the purpose of determination of criminal liability? Any person who in fact directed the others, spoke to them, signed receipts and other documents issued in their name, or performed similar acts on behalf of the rebels. What are the punishable acts under Article 138 of the RPC? The acts are conspiracy to commit rebellion and 2. Proposal to commit rebellion. Note: mere agreement and determination to rise publicly and take arms against government for the purpose mentioned in Article 134, without actually rising publicly and taking arms against the government or those merely proposing the commission of said acts to other persons, proposal to commit rebellion, without actually performing those overt acts under Article 134 are already subject to punishment. People versus Geronimo. What are the acts of disloyalty of public officer or employees punished under the RPC? The acts of disloyalty are the following: FACA. Failing to resist a rebellion by all means in their power. B. Continuing to discharge the duties of their office under the control of the rebels. And C. Accepting appointment to office under the rebels. Note: the crime presupposes the existence of rebellion by other persons. The offender must not be in conspiracy with the rebels, otherwise he himself will also be guilty of rebellion. Q. What are the elements of inciting to rebellion or insurrection? The elements are DIM. 1. That the offender does not take up arms or in not open hostility against government. That he incites others to the execution of any of the acts of rebellion or insurrection. That the inciting is done by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same. Distinguish proposal to commit rebellion from inciting to rebellion. Proposal to commit rebellion as to manner of commission. The offender merely proposes to another the commitment of rebellion, using secret means without actually encouraging the commitment or lending support therefor. Inciting to rebellion as to manner of commission. The offender actually induces another to commit rebellion by his acts and words and does so in public manner. Proposal to commit rebellion as to intent. The person who proposes has himself decided to commit rebellion. Inciting to rebellion as to intent. The person who incites rebellion is not required to have decided to commit rebellion. Sedition. What are the elements of sedition? The elements are REM. That the offenders rise publicly and tumultuously. 2. That they employ force, intimidation, or other means outside of legal methods. And 3. That the offenders employ any of those means to attain any of the following objects. PEICD. To prevent the promulgation or execution of any law or the holding of any popular election. B. To prevent the government or any public officer from freely exercising its or his functions, or prevent the execution of any administrative order. C. To inflict any act of hate or revenge upon the person or property of any public office or employee. D. To commit for any political or social end any act of hate or revenge against private persons or any social class. Or E. To despoil for any political or social end any person or the government of all its property or any part thereof. Can sedition be committed by one person? No. The act must be done tumultuously. An act is considered tumultuous if caused by more than 3 persons who are armed or provided with means of violence. Article 153, paragraph 3. Distinguish rising publicly from public uprising. A public uprising under rebellion contemplates a mass uprising or taking up of arms. It is committed not only by a small band of persons but must indicate a swelling up of mass malcontent sufficiently broad in scope. To rise publicly in sedition does not contemplate such mass movement and may be committed even by a small band of persons, provided that the actions of such band is public and conspicuous publicly, and the band is composed of more than 3 persons or at least 4 persons provided with means to commit violence tumultuously. Is sedition a political crime? No. Sedition, unlike rebellion, insurrection, or coup d'etat, may be pursued for social or economic objectives, such as class struggles, landless versus landed, and thus does not always involve political objectives. It is a political crime only when it is pursued to achieve political objective. Distinguish sedition from rebellion. As to manner of commission, sedition, it is enough that there is a rising that is public and tumultuous in character. Rebellion, it is necessary that there be a public uprising and taking arms against the government for any purpose specified in Article 134. Sedition as to the nature of the purpose, political or social. Rebellion, always political. As to the purpose, sedition, it has for its purpose any of the following objects: to prevent the promulgation or execution of any law, or the holding of any popular election. 2. To prevent the national government or local government or any public officer thereof from freely exercising its or his functions, or prevent the execution of any administrative order. 3. To inflict any act of hate or revenge upon the person or property of any public officer or employee. 4. To commit for any political or social end any act of hate or revenge against private persons or any social class, and to despoil for any political or social end any person, local government, or the national government, or the U.S. government, of all its property, or any part thereof. Under rebellion, it has for the purpose the removal from the allegiance to said government or its laws the territory of the Republic of the Philippines or any part thereof, or any body of land, naval, or other armed forces, or deprivation of the chief executive or the legislature, wholly or partially, of any of their powers or prerogatives. Conspiracy to commit sedition. What are the elements of conspiracy to commit sedition? The elements are AD. That two or more persons came to an agreement to commit any of the acts enumerated in Article 139, and number 2, that they decided to commit it. Is proposal to commit sedition punishable? No. An agreement to both attain an object of sedition and to rise publicly and tumultuously must be present. Inciting to sedition. What are the different acts of inciting to sedition? The punishable acts are inciting others to commit sedition by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end. 2. Uttering seditious words or speeches which tend to disturb the public peace. 3. Writing, publishing, or circulating scurrilous libels against the government or any of its duly constituted authorities. Note: scurrilous means low, vulgar, mean, or foul. What are the elements of the first act covered by inciting to sedition? 1. That the offender does not take direct part in the crime of sedition. 2. That he incites others to the accomplishment of any of the acts which constitute sedition. And 3. That the inciting is done by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end. What are the common elements of second and third acts covered by inciting to sedition? The second and third acts are punishable when spoken or written words. 1. The offender tends to disturb or obstruct any lawful officer in executing the functions of his office. 2. The offender tends to instigate others to cabal and meet together for unlawful purposes. 3. The offender suggests or incites rebellious conspiracies or riots. And 4. The offender leads or tends to stir up the people against the lawful authorities, or disturbs the peace of the community or the safety and order of the government. What are the rules relative to seditious words? Briefly discuss each. 1. Clear and present danger rule. The words must be of such nature that by uttering them there is a danger of public uprising, and that danger should be both clear and imminent. 2. Dangerous tendency rule. There is inciting to the sedition when the words uttered or published could easily produce disaffection among the people and a state of feeling in them incompatible with the disposition to remain loyal to the government and obedient to the laws. What are the elements of the acts tending to prevent the meeting of the Congress and similar bodies? The elements are PAFF, that there be a projected or actual meeting of A. Congress or any of its committees or subcommittees, constitutional commission or committees, or divisions thereof, or B. any provincial board or city or municipal council or board, and number 2, that the offender prevents such meeting by force or fraud. Note: force referred to here is one that produces an injury on the person of another, and fraud involves falsification. Thus, physical injuries and falsification are necessary means to commit this crime. Regalado, Criminal Law. Disturbance of proceedings. What are the elements of disturbing the proceedings under Article 144 of the RPC? The elements are Cody. 1. That there be an ongoing meeting of Congress or any of its committees or subcommittees, constitutional commission or committees or divisions thereof, or any provincial board or city or municipal council or board, and 2. That the offender does any of the following acts: A. He disturbs any of such meetings, or B. He behaves while in the presence of any such bodies in such a manner as to interrupt its proceedings or to impair the respect due it. Reyes, Book 2. What are the acts punishable under Article 145 of the RPC? Enumerate the elements for each act. The following are the punishable acts: UK. Using force, intimidation, threats, or frauds to prevent any member of National Assembly from A. attending the meeting of Congress or any of its committees or subcommittees, constitutional commission or committees or divisions thereof, B. expressing his opinions, or C. casting his vote, and number 2. knowingly arresting or searching any member while Congress is in session, except in cases where such member has committed a crime punishable under the Code by a penalty higher than prison mayor. What are the elements of the first punishable act under Article 145? The elements are U.A.s, that the offender uses force, intimidation, threats, or fraud, or number 2, that the purpose of the offender is to prevent any member of Congress from attending the meeting of the Congress or any of its committees or constitutional commission, etc. B. expressing his opinions, or C. casting his vote. The offender in this act may be any person